apparently, the Supreme Court has now decided, with this far-reaching decision, that the two-step standard that had been in place since Heller versus McDonald, where they analyze the Second Amendment, where it combines history, we have a history, yes, we do, but also means and scrutiny. Does the means of the restriction justify the infringement? And most people would say, yes, we have a right to protect people from gun violence. But I'll simply say in our very quick analysis, because this is only minutes old, they have now said that the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. That's it. No longer can we strike the balance. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Shocking. Absolutely shocking that they have taken away our right to have reasonable restrictions. We can have restrictions on speech. You can't yell fire in a crowded theater. But somehow there's no restrictions allowed on the Second Amendment.
Okay, stop it right there. There's no restrictions allowed on the Second Amendment? Okay, so first of all, I haven't heard her speak very much before. She's either really struggling with this or she's really struggling with lying to you. I think it's the former. All you got to do is read the opinion. And I mean, if that's too much to ask of her because she's busy, because she's a governor, then we should have to ask that of her staff. This is kind of the problem with the mainstream media. They want to get the story out and they want to get the narrative out first. They clearly have not read the opinion, because the opinion actually states that there are reasonable regulations that can still be taken effect on the Second Amendment. It just doesn't include this crazy law prohibiting people from carrying a firearm. And if you're going to talk about the process by which the courts have been deciding this, they touched on that too. And they touched on it for a very specific reason, which, again, you obviously haven't read. Because what they stated in the opinion was that legislators and judges shouldn't be called on to make a judgment call on how a firearms law is going to affect the community. I mean, this is just brazen, I'm smarter than our founding fathers. That's really what this is. These people don't want the Second Amendment to be in place at all. But hey, unfortunately for them, we have a system that upholds this, because ultimately the Second Amendment is what keeps our freedom. So I'm sorry that you found a decision that you don't like and that you can't keep imposing these laws on people, but this is actually the way that our founding fathers saw it. Is every person has a right to self-defense, also when it comes to tyranny, and they do so by having the right to carry a firearm. By the way, this wasn't a right given to us. This is a right recognized by us. I think that's something that's important and lost in translation. Our founding fathers had no ideas of giving us this right. When they wrote it in the Constitution, it was being recognized, period. Okay, let's see what else she has to say.
This is New York. We don't back down. We fight back. And we'll be alerting the public, the media, in the very short term of exactly what our language that we've been analyzing. We have language we'd like to now enact into law. We'll be sharing that with the leaders. And I'm sorry this dark day has come. That we're supposed to go back to what was in place since 1788, when the Constitution of the United States of America was ratified. And I would like to point out to the Supreme Court justices that the only weapons at the time were muskets. I'm prepared to go back to muskets. I don't think they envision the high-capacity assault weapon magazines intended for battlefields as being covered from this, but I guess we're just going to have to disagree. So
Okay, right there.
I'll return to our...
Again, lady, read the opinion. They cover this in the opinion. And I get that you disagree, but I also don't get how you go on live television with Microsoft NBC and start rattling off all these buzzwords as if you have some sort of moral superiority, looking down on your constituents in disbelief. This is ridiculous. You are not the authority of this land. The Constitution is. And by the way, we interpret the Constitution like this for a lot of other things, okay? Television and social media companies didn't exist in, by the way, 1791 when the Second Amendment was put into the Constitution. But they're guaranteed First Amendment rights, are they not? So by that standard, should we not apply First Amendment rights to any of these companies that have any sort of public face? It's time to, and again, just like it was stated in the opinion, it is time to stop recognizing the Second Amendment as a second-class right. This is the only amendment to our Constitution that is viewed this way, and I think the Supreme Court got it exactly right. It's time to stop that.